Good afternoon, everyone, and welcome to the next part of the series of WHS webinars that are being presented by Egypt Insurance, AMIC and AMPC. Today, we're lucky enough to have McKell and Steve Caslick, who are going to present on bullying and harassment and the investigation process. So far, we've got 51 people registered for today's webinar, which is a fantastic result. And I know we've got a number of new people. So I just wanted to go through how the webinar works. Steve and Ken will be presenting. We really encourage questions and we will be keeping the questions to the end. So feel free to write in a question to us. You'll have on your toolbar a question section. If you can just fill it out and that will come through to us. And then at the end, I'll read the questions out to Steve or Ken for them to be able to answer. Please note, because of the topic, we will keep the person's name confidential on who has actually asked the question, because we want to be able to answer your questions, and we do realise that some of the questions could be sensitive in nature. We'll also be conducting a couple of polls through the webinar as well, so look out for those just to be able to make it a little bit more interactive. At the end of the session, this session is being recorded. AMPC will send out to all attendees a copy of the webinar, as well as a link to our YouTube. We've got the whole series of webinars that we've presented up on our YouTube channel, so we'll send you that link. And we're just finalising a workbook that will be made available as well to everyone that's been in attendance today as a ready reference and a training tool. So thanks very much to Steve and Ken, and I'll hand over to you for today's presentation.
Thank you, Amanda, and thanks for remembering all those things that needed remembering beforehand as well. My name is Steve Caslick. I work for AMIC, as you've been told, and I'm an Employee Relations Officer. So the distinguished gentleman with me is Ken McKell. Ken is our business manager here. Ken is also my manager as well, and what Ken doesn't know hasn't been written down. So he has a lot of experience and also has dealt with a lot of different issues. So anyhow, we'll move into the webinar. So as I've said, Ken's the General Manager, Employment and Business Services, and I've already introduced myself, so no need to do that again. So far we've already had 2 webinars, and the first was from Andrew Douglas, and Andrew talked about the legal framework that deals with bullying and harassment in the workplace. He was followed up by Joe McGrath, who spoke about promoting a healthy working environment. And both these particular things reduce the possibility of bullying and harassment occurring. But unfortunately, it can still happen even in the best workplace. So both of them provide the foundation for today's talk, which is about investigating bullying and harassment in the workplace. Excuse me. So what we'll go through today is the definitions. Now, I know you've heard these a number of times before, and we will go through them again. The reason being is I want you to be able to distinguish between what's bullying and what's harassment. There is a case example coming up, as you can see in point 3. Now, Ken and I put that together, and there are a couple of little quirky bits in it, and they're bits that are designed to make you stop and think. So hence, we're going through the definitions again, and we're also going through the similarities. Then we'll move on to the case study, then the investigation itself, which can be quite tricky when it comes to these issues, and then on to bullying and harassment proof in your workplace. So the definition of bullying, which is laid out in the Fair Work Act, is repeated unreasonable behaviour towards another person or group which creates a risk to health and safety. Now, that is a very broad definition. Probably one of the key points you have to remember about this is that it's not just a single person. It can happen to a group of people, and it can also be a group of people that are creating the issue. And also, as the PCBU, it's called in the latest work health and safety legislation, you're responsible once you're aware of stopping behaviours that relate to, well, any aberrant behaviour, which of course bullying and harassment is. So it's up to you to put processes in place to prevent this happening before it occurs. And if you're aware of it and do nothing, then there's very, very serious penalties from either Fair Work or from, Safe Work New South Wales or Australia as well. So just bear that in mind as we're going through it. It is everyone's responsibility to report risks, but it's your responsibility to put the steps in place to prevent it happening or prevent it happening again. So harassment is slightly different, and harassment is synonymous with discrimination as well. So when I talk about harassment during today's webinar, we're also talking about discrimination. In fact, discrimination is probably a more accepted term. So under discrimination law, which you can see includes Fair Work and the Work Health and Safety Act in different parts of each, it is unlawful to treat a person less favourably based on protected attributes such as a person's race or sexual preference, a person's sex or sexual preference, on their race, on a disability, on age or religion. The list is much longer. And as you can see, they're what's called protected attributes. So this is an attribute a person has, which is essentially beyond their control, and you're not able to discriminate or treat a person less favourably because of what's called a protected attribute. So the similarities between the two, there are quite a few, and that is what can make it difficult to determine whether it's bullying or whether it's harassment. Also, these have an effect on the workplace. So going through them, either can target a group or an individual. They may result in episodes of workplace violence. This doesn't necessarily mean it's the person being bullied or the person bullying. I have seen it occur before, and it doesn't mean it's a full-on blue either. It can be verbal violence, it can be a threat. It's anything that can be classified as violent. So it can be friends of the people that have been bullied, or it can be friends of the person that's doing the bullying. And it can create a bit of a division in the workplace and make it difficult for people to work, or less favourable to work. You also may find that you have an increase in workers' compensation claims. And again, that is not necessarily from the person who's being bullied. That can be from friends and other people that are affected, or colleagues, I should say, that are affected by what they've seen happening as well. And again, I've already mentioned, but it creates a divisive working environment. Some people will stick up for one group, some people will stick up for another, and some just don't particularly want to get involved. And some of those people can be very verbal about what they're talking about. So hence the division. Excuse me. We also have lost productivity. When people aren't happy, they tend to not work as well. So a happy workforce is happy people, and that means productivity's up, and also things like your profitability. But I think probably the important thing is that you've got happy staff. Another issue is an increase in staff absenteeism, which means you have an increase in replacement staff to cover them while they're away. And also you'll have a greater turnover. So a lot of people are leaving work, and you're having to advertise for more staff. We're currently aware of the fact that it's very difficult to get people in the meat industry. So it's best, again, to try and reduce your turnover. And also, actually I won't mention it now because it's the last point I want to discuss as well. So we have an increase in accepted workers' compensation claims, so not just claims themselves, because they can be rejected, but we have an increase in the workers' compensation claims being accepted. And of course, the insurance company and WorkSafe will be wanting to know why there's extra workers' compensation claims, and your insurance premiums are going to go up as well. And of course, you'll have less staff. And when it comes to bullying and harassment workers' compensation claims, the majority are mental health, and they're extremely difficult to get that person back into the workplace.
So, sorry, Steve, so really you could say a lot of those are, I suppose, clear warning signs. Trouble is that they're after the circumstance. It's more a matter of the primary focus should be on, well, how can we be proactive and avoid these situations occurring if we can?
Yeah, Ken, that's perfect, and that's something we'll be discussing a bit later in the bully proofing a workplace. But again, that's a very good thing to bring up. Also, you can end up with, whoops, sorry, I pushed the button a bit too soon. What you may also end up with is litigation. Now, Fair Work does deal with issues of bullying, but if that doesn't work, or if a person chooses not to use them, it can also end up in a variety of different courts. Now, those courts end up getting extremely expensive because you'll be looking at having, at the minimum, a solicitor to support you, and of course they have to prepare witness statements and everything that goes with it, and appear for you in court as well, which adds up to potentially thousands of dollars a day. So being proactive can help reduce the cost of litigation. Now, unfortunately, on the opposite side of the same coin, you can do everything perfectly right and you can still have a complaint lodged against you, but we'll talk about that a bit more later on. And of course, one of the important things is that you can lose your business reputation or have it tarnished, which is something you don't want to do. Now, here's the quick poll. So Amanda, get that out there. So have any of you had to deal with either bullying or harassment in your workplace? So it can be a simple yes or no, or you can maybe put a few sentences down as well. It's up to you. We're really wanting to find out how broad bullying and harassment is. So I'll give you maybe 10 seconds or so.
And just to add what Steve said, yeah, putting a yes or no, we're very keen to hear if, for example, you put yes later on when we've got the question time, just to hear not only, without going into too much specifics, what the issue is, but secondly, obviously what process you followed, what you did about it, and if it was successful.
Yes, we always like to hear the success stories, or even the ones that weren't so successful, because we can plan on how to change things that went wrong as well. Okay, so I presume everyone's tapped the keyboards and we can move on.
Yep. So we've got about 6 people that have voted, so we'll close that now. Do you want to have a look at what the results were?
Sure.
Yes, certainly. I'll go back so I don't give anything away. Right.
Okay, so overall the results show that 82% have had to deal with either a bullying or harassment in the workplace, and only 18% have not had that experience.
Well, the 18% are extremely lucky, and good on you. The 87%, look, that stands pretty well with, unfortunately not the national average, but bullying and harassment are very rife in the workplace. That is a high number. But still, it's good to get an idea of how people have been involved with bullying and harassment. And as Ken mentioned, during the question time, you can jot down a few points and send them in about how you dealt with it and whether you're successful or otherwise, and maybe even how you change things. But thanks, Amanda, for doing that and giving the results. Okay, so we'll move on to the case example. The reason I wanted to mention the similarities and differences between bullying and harassment so early, and in fact reiterate them to you, is that the case example we've designed to be a little bit tricky. And what we want you to do is bear in mind, as we're going through this, what's bullying, what's harassment, and possibly what's both, and what are the general warning signs when you read this. So I'll, excuse me, I'll read it. So an employee, Dante, now I'm sorry I chose that name, it just popped into my head, so don't blame Ken or anyone else. An employee, Dante, has come to you concerned that he is being bullied and harassed by his immediate supervisor. This has been happening for a few months. Dante is a single father and a recent immigrant from Africa and a Muslim. He went on to explain that his supervisor makes jokes at his expense, always in a loud voice and always with Dante's colleagues present. Dante remembers a joke about his skin colour and another slighting his religion. For the better part, though, he says the jokes are just aimed at him and not specific. His colleagues laugh at the jokes, but have never joined in. The jokes make Dante feel humiliated and that he is being singled out. He has noticed his workload is heavier than his colleagues. He knows that he is not working to his usual standard, but cannot get out of his current lethargy. Further, he has noticed that he is short-tempered with his kids, and his sick leave has escalated where it used to be very low. He also feels physically threatened as his supervisor is just under 2 meters tall and stands over Dante when they are interacting. He has no confidence in his supervisor, so will not talk to him about the issue. His doctor recommended medication, which Dante has reluctantly commenced. Dante has also sought advice on lodging a workers' compensation claim. Now, I do hope that none of you get something quite so intense, but it can happen, and I don't think it's actually too unusual an example. So what I would be doing first off, you've just heard Dante's comments. Now, I think the best bit of advice I can give is encourage Dante to submit a written report. You don't need to write in on this one, but why do you think it's a good idea to actually have him put in a written report or written complaint rather than just a verbal report? So have a few seconds to think about it. We'll move on to the next slides. Okay, so if Dante puts his complaint in writing, it gives him the chance to clarify the points and make the complaint chronological and succinct. I've been involved in a number of bullying cases. I was a union rep before this, and unfortunately by the time they came to the union, the person was extremely emotional and they just let fly with the information in no particular order. There was tissues, there was crying, there was screaming, there was a variety of emotions. So the opportunity to put the complaint in writing means that that person has to sit down and work out what happened and which order it happened in. If it's just verbal, you yourself have to sort it out, and that does make it very, very difficult to put a complaint together or put an investigation together. It also provides ownership of the complaint, so it means the person complaining, the complainant, has to put everything on paper, and therefore it shows that they're willing to follow through on it. There's nothing worse than being about to put an investigation together and the person that has complained decides that they don't want anything done, or they just don't want you to pursue it because they're worried. But at least if it's in writing, it's showing that they themselves want to keep going with it. And very importantly, it allows the business to read the complaint a number of times and seek clarification if required. And of course, once it's in writing, it's not going to change. If the complainant comes to you with 3 or 4 different versions, then I would be questioning why that was the case. And I would be expecting that once you've received one written complaint, then there'll be very few changes after that. And there's also the final point is it's easier for yourself, the business owners or the HR people, to sort out the fact from the fiction and from the emotions. As you can see from Dante's complaint, he's not specifically emotional, but some people can be. So let's move on to the points that I would like you to hopefully have written down or at least thought of. So what you need to determine from looking at Dante's now written complaints is these particular things. They're just what I've called the key points. So firstly, it's been happening for a few months, which means it's not a single event and does fit in with the definition of bullying. So he's a single father and he's an immigrant. He has a different religion. He's a Muslim. So therefore, that would lean towards discrimination. But at this stage, we're not really sure. Generally, though, the jokes have been about, a few jokes, I should say, have been about the protected attributes such as immigrant, religion, different culture and so on. But generally, they're just about Dante himself. The general points I want to talk about, so just previously, I'd say these particular points are about bullying or harassment. The following points are warning signs. They're ones you should look out for generally. So you will see that Dante, you probably noticed it yourself, or at least listened to or read his reports, you're aware of it. He's not working to his usual standards. He's reported that he's short-tempered with his kids, which is obviously exacerbating or affecting his family life, and also being a single father, he doesn't have the opportunity to get away. He has an increase in sick leave. He's feeling physically threatened. He has no confidence in his supervisor, given that the supervisor is the one that's causing the issue. That's understandable. He's on medication, which he never used to be, and that's reported as a direct result of the way he's being treated. And there is a possibility of him going on a workers' comp claim as well. So they may not specifically be due to or not being something that can point towards bullying or harassment, but they do very clearly show that something is happening. And they're things you'll have to consider and think about and look for when you do get a genuine written complaint. So I've called this laying the key foundations. So you've received Dante's report, you've gone through the key issues, and now you've determined the key points. So you've looked at what the issues are. You have to make a few decisions or ask yourself a few questions. So does the complaint warrant an investigation? Now you've seen it in writing, now you've sorted out fact from fiction, from emotions. And look, if I personally saw something like that, I'd be saying it definitely warrants an investigation. Well, once you've decided that, what you'll have to consider is whether you want an internal or an external investigation. External investigations can be costly. They can be less time efficient, but the advantage of them is you'll have an unbiased investigator. If you do it internally, the person that has been dealing with Dante, has received the complaint and looked at the issues, may not be the best person to follow through with the investigation because they've already been tainted by what's been said. It may be subconscious, but you may find that you're supporting his supervisor. You may find that you're supporting Dante. And what you would have seen is all those emotions come up. So you're not looking specifically at facts. So my advice, if you can afford it, if you have someone else, would be to get someone else from this point, take on the investigation. Now you need to ensure, or how do you ensure fairness and transparency? You need the people involved in the investigation, the complainant, complaining and witnesses to be aware of exactly what's happening all the time. You have to make sure everything remains confident. That's goes without saying, really. But what can happen, as I mentioned before, you can end up going to the Fair Work Commission. One of the important things to be able to show a commission member or a judge, if it comes to that, is that you've been fair and everyone's aware of what's going on and nothing has been hidden. One of the first things that that judge will ask you is, where are your policies and procedures? And did you follow your policies and procedures? They want to make sure that the investigation itself was unbiased. Now, keeping accurate records, this has an issue for a lot of people. You need one of these. I can't see the screen where I am, but I'm hoping you can see that. So one of these and one of these, that's all you need. And you need to be able to keep them in a secure place. So a notebook is admissible in court, in the commission, as evidence. So what you need to be able to do, and I stress it over and over and over, and Ken does as well, is you need to keep accurate records. That doesn't mean you need 5 or 6 pages. All it means is you open the book, you write the time and the date on it, and the day as well, which is handy. Write down what was reported to you and what you did about it. That's all you need to do. There is a particular word for it, I can't remember it at the moment, But essentially, you're writing down exactly what happened. They don't have to be fancy, but they need to be legible for someone else to read. So again, a notebook is admissible in court, and what that's doing is showing that you've kept good records of what's happened. So the people involved, what occurred, what you did about, and potentially if it breached the company policies and procedures as well. Also, talking about policies and procedures, while considering Dante and the issue that's occurred, you need to determine how the company or business will prevent or reduce the chance of a similar incident occurring, I left out a word, sorry, in the future. So do you have everything in place? A, you use it for the current issue, but B, if it happens again, will you still have possibly the same policies and procedures in place or better policies and procedures in place? In fact, you need to determine whether you have any at all, which is exceptionally important to do, because if someone comes and looks at your records, such as safe work, you will not be held in very high favour if you don't have any records at all, policies, records or procedures in place. And also have a look at whether the issue itself is serious. It may be, for example, Dante was hit or he hit someone else. So that in itself can be an illegal action by the law, and you would have to deal with it that way as well, which can result in an instant dismissal, but just determine at what level, how serious the misconduct is. Bullying and harassment rarely gets to that level, but it can happen. Okay, sorry, I thought I'd gone too far. So stage one of an investigation is about interviewing the complainants and the witness. But at this stage, you also need to inform the complainee, that's the person who has been complained about, in writing of the complaint. Now, at this stage, you're not fully aware of what the allegations are. So all you're doing is writing to this person and informing them that a complaint has been put in about them. And you'll have a follow-up letter about the exact allegations itself, and I'll talk about that in stage two. So we're presuming you talked Dante into putting the allegations in writing. So when you speak to the complainant needs to be spoken to first. So you've got all the allegations in writing, or all the issues in writing. You've been able to separate the fact, fiction, and emotions. And also, oh, sorry, you're now at the point where you want to interview witnesses. But of course, this stands the same for anyone you're interviewing. So the first thing you need to do, or that I'd recommend, is listen and take notes, or consider a recording. Excuse me, but of course, a recording means that you have to get the appropriate permission prior to doing it. Now, the advantage of the recording is it's an exact verbatim verbal copy of what has been said. Now, you can have this put into a transcript, and you can return the transcript to the person interviewed, and they can go through it and make sure that what they're thinking is what they actually said. And it's a good idea to have them sign each page, at least to say that they've read it as well. So listening and taking notes. Why do I say listen at least the first time? Because what you're wanting to do is just let the witness, or let the person you're interviewing, I should say, get all the information out. All you need to be doing at this time is writing down a few points on things you need to clarify. But you want to make sure, at least the first time they speak, that you don't interrupt and potentially taint their witness statement, because that is something you don't want to have happen. I know if it came to the commissioner or a court, one of the first things the person who put in the witness statement would be asked is if it is a true and accurate reflection of what they said. And if it's not, there's going to be fur and feathers flying. So make sure they get the opportunity to go through it all first, and then you can ask notes. Don't offer suggestions or different wording. Let them do it. So really what you're wanting to do is ask the witness what they saw or heard. For others involved, determine if there's any substance to what they're saying. Determine if the conduct, again, was serious or otherwise, rather than of otherwise. Sorry about that. Avoid assumptions. So you may know the particular people that are talking. You may know or may think that they're a gossip or a troublemaker or something or other like that. Try and avoid that, because that will taint what you're looking at as well. And again, that's why I'd be suggesting a different person go on and do the investigation. Oh, and of course, my last point is be cautious of influencing the witness's account. Let them talk, don't interrupt, just listen. At this stage, your job is to kind of provide them with a glass of water and make sure they're getting on okay. Now, any party being witnessed is entitled to have a witness with them or a support person. I would be suggesting very strongly that you, as the interviewer, also have a support person with you. And the reason for that is that that person can be taking notes, and you can focus wholly and solely on getting that person's or getting the witness's account of what has actually happened. It gives you the opportunity to focus and not worry about anything else. So make sure you have someone with you to take notes and to act as a witness, and the others are entitled to have a witness as well. The people being interviewed are entitled to it. AMIC recommends quite strongly that you provide them with this advice. You don't legally have to, but provide them with advice that they can have a witness with them. But of course, it's not the witness's job to advocate for them. They can have a friend, they can have a colleague, whoever they want. The only way, you can't actually say no to them having a support person with them unless there's going to be a conflict of interest or something along that line. So they couldn't really have another witness to the issue be their support person. So it's a bit of common sense. Also, if the person that's with them, the support person, starts to get stroppy, the behaviour goes downhill, you're entitled to actually stop the meeting after explaining why, reschedule the meeting, and obviously have a chat with the witness and ask that they provide another support person next time. The witness chooses their support person, by the way. You can't provide anyone for them. So at this stage, you've received the complaint. You have made sure it's in writing. You have looked at it. You have read it, you've clarified it, you've interviewed the complainants, and you've interviewed all the witnesses. You've looked at all this information, you've compared it with company policy, and you've determined that you need to continue with the investigation. So the first thing you need to do is to inform the complainee of the allegations. Remember, the first time it was just the fact that a complaint had happened. Now you've been able to work out what the allegations actually are and how those allegations go against company policy. So you need to provide the allegation, you need to inform the complainant of the allegations. I would be suggesting a meeting. Don't stand in the lunchroom and flick them a letter across the rest of the workplace and say, mate, here are the allegations we told you about. So what you need to do is pull them aside, 10 minutes, inform them that these are the allegations, hand them the letter in a sealed envelope so no one else can read it. You need to inform them of confidentiality and just give them a bit of time to get used to the fact that the allegations have been made against them. They could explode, they may get really upset. It's just a case-by-case basis. Just give them the opportunity to sit down, read it, ask any questions they need to. So maybe 10 minutes was a bit short. Then organise a further meeting with them. You need to give them a bit of time to prepare for the meeting. The next day is fine. So then you interview the complainee. Again, they can have a support person, and the support person should be there for both you and the complainee. Of course, at this stage, it's very important that your notes are accurate, and you need to provide, or you need to show, in case it does go to a dispute, that you have provided a right of reply to the person that complaints are about. And that simply means that you're listening and allowing them to provide their version of events. Last point, which is really important, is provide the complainee a transcript of the meeting. So the minute notes, they need to be able to have a look at it and say, yes, these are true. This is exactly what I said, which is okay when you've recorded it. But if you've just written it, they need to provide it with an opportunity to have a look at it and see if there's any mistakes in it. Again, that's about transparency. So stage 3, now it's getting interesting. You're looking at the outcome at this stage. I won't go through it all again. Got the complaint, you've interviewed everyone, you've interviewed the complainee, the person that complaint is about, and now you're looking at all the information, you're comparing it with company policy and procedures, and on the balance of probability, you determine if any of the allegations are substantiated, if some of them are substantiated, or wholly substantiated, which is all of them. So compare the investigation findings, as I've said, to company policy and procedures. You also, well, it's actually not so important at this stage. This is something the person that's making the final determination will let you know about or take into consideration. But at this stage, you can also take into consideration the employee's previous performance. Have they been a good employee? How long have they worked for you? If they've been with you for 15 years and never had one thing against their name before, then you can take that into consideration. If they've been with you 5 months and they're always picking on someone, well, take that into consideration as well. Now, also look at whether there are any extending circumstances. You know, is their partner really sick? Have they just had a child, which would be keeping them up late at night, as you who have children would be well and truly aware? And very importantly, is the employee contrite? So I should say the complainee, is the complainee contrite? Are they sorry for what they've done, or are they placing the blame on the person who actually can put the complaint in, or putting the blame on everyone else? So are they taking responsibility for their actions? So as I've said, the allegations can be unsubstantiated, partly substantiated, or wholly substantiated. Once you've put your report together and finalised it, give it to the decision maker to determine if and what disciplinary action will occur. Generally, you wouldn't provide recommendations in the letter to the decision maker. What you would be doing is, of course, it's going to be in writing. What you'd be doing is putting all the allegations down, and you'd be putting whether that allegation is substantiated or whatever the outcome for that particular allegation is. Sometimes none are, sometimes they can be 10. I had one guy once, there was 48 allegations made against him, and unfortunately most of those proved to be true. Or you can have them all substantiated. You just have to go through it and look at the supporting information or supporting evidence. So provide the report to the decision maker. They will determine what, if any, disciplinary action will occur. Once that's done, have a meeting with the complainee and inform them that you want them to attend a meeting, and you will provide them with a letter outlining the allegations, the finding, and any disciplinary action. Again, this is an extremely difficult time for that person, whether they've engaged in the bullying, whether they're a nasty person, whether they're contrite. Just be aware that emotions can be quite overwhelming at this particular stage. So the disciplinary action can vary depending on the outcome. So it can be a caution, which again is something that should be in writing. And if you're doing that, you need to provide a letter that lists the fact that they've been investigated. Of course, a caution would mean that at least 1 or 2 of the allegations have been substantiated, and that you would expect nothing further to happen from them. Another low-level disciplinary action is training. You may just find that they just need to have a reviser training, and you watch them for a few months. You can temporarily or permanently demote them. You can transfer them, but it must be a reasonable transfer. You can't have them working at Bega and decide to, I don't know, move them to Tibooburra, for example. It may just be that they transfer to another unit within the business, or you move them a couple of miles off. And that can be a temporary or a permanent transfer. Again, probation's the same. You can decide that you will have them on probation for a given period. This is also something that needs to be in writing, and you also need to be informing them quite clearly when the probation finishes and what the company expectations are leading up to the end of that probation and what will happen if they don't pass that probation. Now that has to be written into the letter. So you have to say further disciplinary action will occur and it will include termination. A person has to be aware of what's at stake. That's just part of fair work as well. And of course, the final one is that they can be terminated. And of course, unless it's serious misconduct, you have to provide them with any pro rata long service leave, any accrued holidays and so on. You would treat the payment as the same as if they resigned themselves. Now, getting onto something that hopefully will assist you is as bulletproof in the workplace. Now, there's two approaches. The first one is the wrong one. Do not do yesterday what you can do tomorrow. The procrastinator's motto. And this can, I've just written underneath, as you can see, it's giving, well, it's people saying, he's giving Dante a bit of stick, so you've seen it happen. Let's see where it goes before we butt in. It may resolve itself. Well, yeah, it might, highly unlikely. And if you're inspected by a government organisation, say Safe Work, they will look at that and you're going to be in a lot of trouble because you're aware of it, particularly under the work health and safety laws as the PCVU, the person conducting the undertaking or business. You can't sit back and watch it. You're aware it's happened. You need to do something about it straight away. Now, the other way of bully-proofing is to don't do tomorrow what you should have done yesterday, which is the best approach. And this is about having policies and procedures in place. It's not waiting till something happens before you do it. It's having all of this in place before the issue occurs. So when it does occur, you've got everything in place to deal with that issue. And judges, commissioners absolutely love it because you've shown you've done the right thing in trying to resolve it. And you've prepared for it before it's happened. Now, I would strongly recommend staff engagement in developing your policies as well. They're on the ground, they see issues slightly different to what management does. So involve everyone in the development. That means they feel they have ownership over the documents as well. And they feel a bit prouder when they see it on the website and know that they were part of that development. A third point is proactive intervention. So when you hear of something happening, when you hear the whispers, act early rather than later. It may be nothing, but it also may turn out to be something very drastic. I know we hear constant examples of people that have actually suicided through being bullied. You don't want that to happen. That's when it gets to the worst particular place it can go to. Now, Ken and I had, well, I should say I, but AMIC had a phone call a few days ago. It was from a member, I can't remember where they were, but he was very distressed. He just received a call from, it's not about suicide, so don't panic. He'd received a call from Safe Work to say, mate, we've had a complaint of bullying against you. It was a colleague who worked there 5 months ago, and we'll be in there in half an hour to look at your records. So he rang us straight away, and our advice was, be honest. Show them that they want to, show them what they want to see, show them your policies, which he had in place, show them the procedures, and have them talk to the people involved in what the issue was. Now, I haven't heard back from him, but the person that put the complaint in was a serial complainer. They lodged grievances against government department and all sorts of people. So it seemed as though they were someone who just liked to complain when they didn't get their way. The difficulty of it was the person, to some degree, was disabled as well. So that made it look as if it potentially could be discrimination. So I'll have to call him and find out what the result was, but fortunately they had everything in place. And he said 25 years he's owned a business and never had a complaint against him before. So he was a bit shaken up, but I said, be honest, that's all you can do. And if something's gone wrong, then take it on the chin and fix those procedures and policies up. So the next point is induction training. So as soon as someone starts for you, well, it's not obviously going to be the only training, but it'll be included in their training. And also refresher training for existing staff at regular intervals. Important one is zero tolerance. So don't put up with any of it. If you hear about it, be proactive, do something about it. Also, the person being picked on, being bullied, being harassed, may not feel as though they can come to you. So if they have friends or another staff member that sees it, allow that person to come in and talk about it. You can figure out a way to watch what's going on, or you can figure out a way to talk to the person that's actually being bullied and get around it that particular way. All right, so the final poll, one important question I forgot, one important point I meant to make is when you have received the complaint, ask the complainants what they want as an outcome. Now, it has to be a reasonable outcome. It can't be putting the complainant in the stocks and throwing tomatoes at them in the street square. It can't be boiling them in oil, but it might be something like an apology, to see that person trained. It may be that they want to transfer, just things like that. It has to be reasonable, but ask what they particularly want, because they might not want anything to progress any further as well. But anyhow, time to put fingertips to keys again. Did you use a similar process when you dealt with bullying or harassment in your workplace? And when it comes to the questions a bit later, we'd just like to know if it was effective, if you've got any ideas for us to change what we've spoken about today. We're always looking out to improve and refine what we put together, but just let us know how you dealt with the bullying issue. So, I don't know, another 10 seconds or so. We've only got about 13 minutes left, so I don't want to take too long.
So, Steve, I just had a couple of, I suppose, comments. And again, this is all from experience and looking at the 82% that said that they've had a bullying situation. They might relate to this pretty much. But one of the areas that comes up from time to time as a question is, well, what if it's just one word against the other? And let's say there's no witnesses to it, and it's a matter of how that's going to be handled. So obviously you do exactly what Steve has said about going through your investigation. You're asking for it in writing, so you can specifically relate to see what you have to investigate. As I say, no witnesses. So then, of course, you're going straight to the aspects of speaking to the complainee and following the same process. But again, it may come to the point that obviously totally diverse comments, views. So unless you find something out through further investigation that catches one or the other out, it might very well come to the point, and I'd be keen to see if anybody's got a comment on it. It might come to the point where, well, the allegations aren't proved. However, then you still reiterate to both parties of referring back to the company policy where the company's position is in relation to these issues if they were possibly later proved, or worse, for the complainant, it's disproved and it found it was false allegations against the person that they're complaining about. The other area that when you look at that case study, although the specific details wouldn't be exactly the same of what most of you experienced, I would think or hope, it does raise the point about, one, there's witnesses there, and this has been going on for a while, but nobody has fronted up, and talking about what Steve said, the open door policy, nobody's fronted up or made a complaint, even confidentially, about poor old Dante or whoever. And of course, that's a concern because it can come back to, unfortunately, the culture in the organisation. And I'm talking about if the accusations are genuine and proven, that why those people didn't come forward. And look, I've had a number of occasions, and you may have experienced it as well, where it goes through the whole process, and let's say the person's been terminated, and then people come forward and say, oh, geez, I'm glad you got rid of them. I was abused as well.
Yeah.
And you think,
Yeah.
well, hang on a second, we've got a policy. Why didn't you bring this to our attention? So again, they're just a couple of points that come out. And look, each case stands alone. But again, the seriousness of this is not just on the company and the person being accused, but any person working there. So I thought I'd just add those couple of subject areas.
No, great points, Ken. And if someone witnesses bullying and doesn't come forward, it's called tacit agreement. And unfortunately, that means that they're agreeing with the bullying action because they've done nothing to prove they're not. I can make it entirely about me for 30 seconds. I was bullied a number of years ago, and my colleagues, and a lot of that was without witnesses, but a lot of it was with witnesses because she just couldn't help herself, and there was another person before me as well. What happened was my colleagues said, look, we know you're bullied, we feel really bad about it. And I said, well, can't you tell someone? And they said, no, because if we do, she'll pick on us. They were too scared. And I ended up moving on, and she did end up picking on another person, and it was the person that kind of stuck up for me. So, yeah, it's a difficult one. It's particularly difficult when there's no one else around. But it just means, you know, in cases like that, you put them both through training again. You remind them of their obligations as an employee. You have them reread policies, and you watch them. Now, the unfortunate thing about a bully is they have to bully, and eventually they'll start doing it again. So, but Ken, they were very, very good points and very valid points. Amanda, how are we going for our second surprise poll?
Yes, so the poll results are up. 96% said that they did use a similar process when they've dealt with bullying or harassment in the workplace before, and only 4% said no. So that's good to hear that a lot of people are following a similar policy and procedure.
That's really good. Now that means that all of us are getting it wrong, or we were spot on the money with the webinar. But I'm presuming we're all 94% of us are right, so we'll just take it that way. Okay, questions.
All right. Oh, yep, you're on to questions. So if anyone wants to send in a question, we've got a couple that have come through, but please feel free to type the questions in the toolbar. So the first question for you, Steve, is if the situation requires, should you ask the complaintee if they need a translator?
Oh, sorry, yes, by all means. Language can certainly be an issue, and I've had to deal with a few of those in the public service. Sometimes that's a cultural difference. What you're saying is something I don't understand, or it means a different thing in their particular culture. So yes, by all means. Very good point. Great question.
The next question is, how often should all staff undertake refresher training for bullying and harassment?
Ken, happy for your thoughts on this one. Mine are, it's very much budget conscious issue, but refresher training can literally be a 15-minute toolbox talk, so it's not exactly an onerous expense. With bullying being such a prevalent issue, I would be suggesting between a year and maybe 15 months. Ken, what are your thoughts?
Oh, look, yeah, as to a time period, I suppose that having, like any policy, apart from if you're updating it, is to revisit it. And of course, you're always going to get new employees come along to the establishment. But again, I suppose most definitely, not that it's solely guided by it, is that if there is an incident that occurs, however lightly, then there should be a revisit to the policy. It should be made clear, reinforcement of what the steps are. Look, it might be something that happens in the media somebody's talking about it, people are talking about it in the lunchroom. Again, it's just a matter of coming back and talking to people about it, which just reminds me, sorry, I'm conscious of the time, just reminds me again that whenever you're doing a policy, particularly even if it's in bullying harassment, is have employee involvement in the development or upgrading of it, to not only have ownership of it, but accountability for it as well. So you've got people that can't deny later on, oh, well, I never got that policy, and I know you would have expectation done it from their induction. Trouble is that might have been 3 or 4 years ago. So it's always best to, 12 months. Yeah, look, I think that's a good guide if you haven't had any particular cases or none that you're aware of or none that have been reported. But yeah, I'd say that's a reasonable guide. If people want to do it more often, not a problem.
And certainly I would say 15 months at the max, but if you're having bullying issues, then make it a lot sooner. It's good to remind people while it's happening. And in my role here, Ken and I have developed a number of policies, and what we've got on the bottom of them is a revision date. So we think about a year, have a look at the policy, make sure it's still relevant. If it is, just sign it off to say revised and put another year underneath it. You may not need to make changes, but you may find that the tweaking your policies once a year, or at least looking at them, means you're keeping up to date. You don't want to go to court in 2020 and have written on a policy that it was developed in 1980 and hasn't been looked at since. It's not a good look.
Right.
So any more questions, Amanda?
The next question that we've got for you is, if the person brings a support person and you feel that that support person is inadequate, maybe they cannot understand, and therefore we need an interpreter, or may have had issues within the company previously, can you actually just hire that support person?
Oh, now that's a tricky one. So my initial response.
Yeah, go on.
Oh, good. Saved. Good, I can go for it.
No, look, and again, this will be in the workbook that you'll get later. But the principal point there is support person, and why we've put that in there is this is very similar, and hopefully you haven't had too many, to the likes of unfair dismissal matters, adverse action claims, etc. So the purpose and the definition of the support person is a person who is not a spokesperson. So look, it usually could be the union delegate, union organizer, fellow staff member. A lot of the times people will say, no, I don't need a support person, probably because they think they're going to hang themselves anyway. But with a support person, as I say, they're not a spokesperson. They're there to just give them, I suppose, emotional support, but also to just discuss with them, maybe give them advice. But as far as if it's a language issue, or you're thinking, look, I suppose you're sort of taking a little bit of the side of that person being interviewed, that look, I think you need to get somebody else so that you understand it, or more importantly, probably take away the excuse that they can later on say, oh, that's not how they explained it to me, sort of thing. So yeah, you can raise that, but most definitely it comes back to that individual, the complainer, the complainee, witness even, that they can choose who that person's going to be within reason. Not talking about going to get a solicitor or a barrister that's going to take 2 or 3 days to get there. So, which some of them put up.
Oh, sorry, Ken, to interrupt.
No, you're right, mate. Yeah.
If you get a barrister or a lawyer, they still have to follow the same definition of a support person. They can't be there to advocate for you. Not in this interview. Of course, if it goes further and falls within what a solicitor or barrister does, yes. But as far as this particular interview, their role is not to advocate for you. It's just to be there with you. So, Amanda, anyway, actually, we can keep going through questions, but I just flipped to the last slide. Sorry?
One last question. Can the support person be a union rep?
Certainly can. I used to do supporting role very, very often. And one of the first things I'd always take with me is a box of tissues. And 6 times out of 10, the tissues were used. So really you're there to support, make sure that person is feeling okay. If you see that person getting too distressed, that you can ask for a break. And you can take them outside, walk them around, make sure they're okay. But yes, a union rep can be a support person, but they have to follow the same rules. They can't go in there and carry on and rant and rave. They're there to be a support person, not an advocate at that time.
And I just quickly add to that point with the union official, look, sometimes it can be advantageous that it is a union official, whether it be delegate or organiser, again, without holding up the process, saying they're going to take a day to get there. Because if there's a possibility the matter goes on, they were directly involved in the meeting. They heard what was said. They've possibly even seen what the allegations were front up, and therefore it makes it less likely that that organiser and or union may take the matter up on their behalf.
Very true.
Consider that.
And just the same, they're involved in the solution rather than the problem as well. So we've gone into 1 minute and 19 seconds overtime, Amanda. So if there's no more questions.
I'll let you, yeah, that was the last question. So I'll let you put the advisory line.
Okay, so what we have now is an advisory line that's been open for, Amanda, 6 months, if not longer.
Close to that, yes.
Close to that. So the point of the advisory line is for anyone who wants to can ring up a general number, and then it gets transferred through to someone who knows about workers' comp, another person, workplace safety, and probably myself at AMIC, which would do the Human Resources and Industrial Relations Commission. So please, by all means, use that number. It's there to provide free advice, and it's there to help you resolve the issues. And as you can see, it's 1300 761 891. So make good use of it. Thank you to everyone who's attended. Appreciate you putting that hour's time aside. If you have any issues, use the line, or you can also email Amanda or actually Simon from Aegis. They will pass the information on to us. And of course, AMIC members that are listening know what the routine is to get in touch with us. So thank you for listening.
Great. Thanks, Steve and Ken, for today's webinar. We really appreciate the time and the effort that you've put into being able to deliver the webinar today. And once again, I reiterate what Steve said, really encourage people, if you've got questions or anything that you didn't want to raise through the open forum question bar today, please get in touch with Steve or Ken through the advisory line. They'll be more than happy to have individual conversations around your particular requirements. So that concludes today's webinar. I just wanted to let everyone know next week we have the final WHS part to the workplace bullying, and that's actually going to be presented by Simon Booth from Aegis Insurance, and it's going to be around managing claims liability with bullying and harassment claims. So I believe an EDM has been sent out for that this afternoon. You can register in the same way, and we look forward to seeing everyone then. So thanks very much again, Ken, Steve, and for all our listeners that participated in today's webinar. Thank you.
No, pleasure.
And Amanda for putting it all together as usual.
No worries. Thank you.
All right, everyone. Have a good day.